Happy Friday Night Live, y'all. It's been a week. Today has not slowed down at all. I gave the text crew voting rights on the color of the lights, and it was kind of a toss-up between pink and purple and blue. So we went with Galaxy. They're Galaxy lights. That's what we're going with. Pink and purple and blue. We're at 129,000 subscribers. It's bananas. The paw nerds are breaking into the stream already. I've got to tell you about these cats before we even jump into it. I have 5-month-old littermate ginger boys named Fred and George. They're amazing. But today, Fred has had a day. We all know these days with our pets, he has had a very high need. Hi, buddy. He has had a very high need day. He has just needed love and attention. And today was just following me into the bathroom. This is not going to be TMI, I promise. But this cat, Fred, the most mischievous of the Fred and George set. Is somebody coming to reclaim the cat?
I was wondering where he went. But first,
it's time for him to eat.
There's something you have to say to him.
What?
No.
Mischief managed, Fred.
No,
mischief
sorry.
managed.
You have to say sorry to him.
Why?
You know why.
That wasn't my fault.
Say sorry.
It's not my fault. I'm about to tell the law nerds what happened. It was not my fault. That was Fred's fault. Mischief managed, Fred. Good evening. So this cat, this adorable paw nerd of mine, 5 months old, was following me into the bathroom all day today. Just all day. High need today. High need for attention. And what I didn't realize is that he was trying to hop up onto the counter in the bathroom, and that he uses the toilet seat to do such. But I had lifted the toilet seat, and when he went to jump onto the toilet seat to get up to the counter, he jumped into the toilet bowl and was not pleased. I think he hit the wall in jumping out of the toilet. Very wet cat. He just splashed the wall, splashed the floor, and went running out of the bathroom that is adjoined to my office. He was not pleased with his toilet bowl splashdown, and I was not pleased with trying to chase a wet, toilet-watered cat through my house. Literally moments before I had a collaboration Zoom call with another creator that will be out next week. But as I'm getting ready to do this collab, before I go on stream, it's kind of the last thing to do is to pop into the bathroom, last possible moment, because when I stream, it's normally an hour or two. I have had 2 children. Bathroom is necessary, but this cat jumped into the toilet. Yep. So there's that. I had this is going to be the cat that also like falls into the bathtub when I'm bathing. This is the one. George is a little more cautious. Fred is a maniac, and we love him for it, but he is wild. He is a wild cat. Let me tell you what's coming up tonight, and then if you are in the replay crew, why is talking hard tonight? We're going to take a drink in a second. Replay crew, we love you. Let me know in the chat if you're replay crew. Let me know down below if you're replay crew. There will be timestamps so you can jump to what you want. We're going to do a weekly roundup real quick, rounding up the topics. I should get a video. We should do a video for weekly roundup, like a yeehaw kind of. No, that's too much. We'll figure it out. Something. Well, we do ride at dawn. We need a roundup. We need the legal roundup. The legal roundup. Legal roundup tonight is going to include TikTok, Triller, Jen Shaw, and Tati Westbrook and KJ. Yep, that's the weekly roundup. And then when we get into our dives for this evening, we've got some Girardi updates. Ron Richards has responded. Well, not really. The trustee who's trying to appoint Ron Richards has responded. And since we covered the objection, we're going to cover the response. And then Hayley Paige gets denied by the courts again. They are not having any of it. And the more I talk about Hayley Paige, look, the more that sponsored Hayley Paige posts keep popping up on my Instagram feed. I talk about the girl on the YouTube, and on the Instagram, all that glitters on the gram, like pet ads, keep coming up on my feed. So when you are popping into the chat, I am so glad you are here. Let me know where in the world you are watching from. You do not have to give your specific location. General state and or country will work. It's time to get rolling. I've got vodka and lavender synergy kombucha tonight. Let's ride, y'all. Let's ride. I like the reference to regulators mount up. That might need to be our weekly roundup. Regulators mount up. It was a cold, dark night, a cold blue stream. I love that song. I love that song. Let's get into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show. I don't know what happened. That was probably me. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. It's so good to see you all coming in from all over the place. Hello, Canada. It's always good to see you guys. And I was drinking and then didn't pull up where everybody was from, though that's what I try to do when the song is playing. I try to pull up where y'all are from. Hello, Puerto Rico. Veronica, how do you feel about the Paul brothers taking over the beautiful Puerto Rico? I love Puerto Rico. There were a number of Puerto Rican women on my college water polo team. We had a lot of fun together. We had a lot of fun together. Peggy, hey girl. Love you. Good to see everybody. Good to see all of the law nerds. All right. Oh, Tennessee in the house. I see Tennessee in the house. I see somebody drinking sweet tea from Sweet Home, Alabama. Love me some sweet tea. And I feel like I get to just drink sweet tea in the South, because if you're in the South drinking sweet tea, I don't think it has calories. I think that's how that works. So Pamela, I love these Corksicle glasses. We need a Corksicle Law Nerds collab. I'll tell you what. Lori, welcome to the chat. Okay, should we get into the weekly roundup? We should. We should get into the weekly roundup. Hello to our friends over on the Facebooks. Hello, Corey from Anaheim. House of the Mouse. Dude, House of the Mouse. Look, I am so happy to move to Tennessee. I love Tennessee. It's a beautiful state. But Avengers Campus just opened, and there was a part of me that was very sad that I am not within driving distance of Disneyland anymore, because I want to see Avengers Campus. The next time I am in California, I will absolutely be going to Disneyland. So if I am in California, there will be a Disney trip for sure. It's so good to see everybody. Southgate. I used to prosecute in Southgate. This one. He's going to be here all night. He is going to be. Fred, you're welcome to sit, but no mischief. No mischief. Hopefully he'll just chill. Yeah, go ahead and lay down and chill. If you're new here, you can put a 1 in the chat. I'm Emily. I'm your favorite ADHD and dyslexic legal commentator, and I get distracted easily, which is why I don't normally have the law nerds or the paw nerds in the office, because they do distract me. But it just is what it is. It is what it is. Oh, can't get into Disneyland. Tickets are sold out. Must plan months in advance. Disneyland is residents only, months in advance. Absolutely. Hello, Tokyo, Japan. All right. Let's get into this. You guys, how are we feeling about YouTuber boxing? Like, I'm seeing that we're going to be getting like potentially a ladies of YouTube boxing, with Tana Mojo teasing that she and Gabby Hanna might want to go punch each other in the face. YouTuber boxing is like a whole ass thing now, and I don't understand how it became a whole ass thing. Little kitty cat, hello. Just wanted to celebrate with you all, because after 3 years of fighting rheumatologists, I finally got a diagnosis of arthritis and can start treatment Yay. Most don't believe me because I'm 21. Look, arthritis can happen at any age, little kitty cat. I'm so glad you got a diagnosis. Good on you for advocating for your health. It can be exhausting. Healthcare advocacy in the States can be absolutely, absolutely exhausting. So thank you for that. But this whole like YouTuber boxing thing is just gotten wild. So we are getting a fight on Sunday. I might pay to watch it. I might pay to watch it. If I watch it, I'll let y'all know what I think. I might pay to watch it. I want to see Floyd Mayweather hit Logan Paul in the face. I do. Azaria said, I got my boomer dad who works in as a Dep sheriff in law enforcement. I'm a crim student to get hooked on your vids. Hello, Dad. Hello, Azaria. Welcome, Deputy Sheriff. I was like, Dep Sheriff. Yes, Deputy Sheriff in law enforcement. Well, in California, I worked quite a lot with sheriffs. I very much enjoyed them. So not only has YouTuber boxing taken over the world as being quite lucrative, you've got, Jake Paul signing deals with Showtime Boxing, which is actually like a legitimate thing. But then you also have this TikToker YouTuber boxing event that's being hosted. And TikToker YouTuber boxing is just that. It's TikTokers and YouTubers facing off against one another. So I'm going to pull up this article from Insider. Hold on. It's making me log in. I was logged in. Insider, I was logged in. Please don't fight with me. I was logged in. I was logged in before the stream so I could just pull stuff up. And now it is logging me out. And I am just like, why are you logging me out? I was logged in. So with regard to the TikToker YouTuber boxing event, this event seems to be emceed, I think, by Keemstar. I don't know who a lot of these people are. The big ones that I've seen that are fighting each other are Austin McBroom from the Ace family and Bryce Hall. Yeah, that seems to be the main event. But it seems that the YouTubers versus TikTokers amateur boxing event has been issued a cease and desist. The cease and desist indicating that TikTok's logo is appearing on the event's website. Let's go to the event's website. I don't see the TikTok logo anymore. Let's see. Battle of the platforms, YouTubers versus TikTokers. It doesn't say YouTube versus TikTok anymore. I don't see the TikTok logo. It does say TikTokers. But it seems that the battle, there's the logo. The battle of the platforms. The issue with the cease and desist is that TikTok said that they don't want their logo used. They say that the event is promoting violence. It's boxing. So yes, violence, but it's like consensual violence. Like it's not as if somebody's getting jumped. It is consensual violence for a lot of money. It is an exhibition. I think a dance-off is a great idea at Dev's Dollhouse, and we should make them all like pick a TikTok dance that they have to learn very quickly, but I feel like TikTokers would have the advantage. What would the YouTubers do? It's like you have to pick a TikTok dance and you have to play Call of Duty. And whoever does better at those two things, you have to do both. Because I think a lot of the YouTubers would do better in the Call of Duty playing, and the TikTokers may be better with the like dancing situation. Either way, so a cease and desist apparently has been issued to Live, whoever this company is that's hosting this event. This event is coming up quickly. TikTok is asking for the event to be stopped because they don't want their logo used. Amazingly, YouTube was like, yeah, YouTubers call themselves YouTubers like all the time, and we're totally cool with it. We're glad to see YouTubers being enterprising. And that was in a statement that YouTube gave to Insider. And every time I change away from this story on Insider, it logs me out, and I don't know why. So we are not going to pull that back up because it keeps logging me out. Business Insider, what with peace and love, man. Stop logging me out. We're trying to do a live show. I run this by myself. It's not by myself. It is with the mods and with Tech Valor, but when I am having tech difficulties, it is me that is trying to fix them. So the event spokesperson said that the organizers have recently become aware of an email which appears to have originated from ByteDance, the parent company of TikTok, asking for the event to be canceled. Social Gloves taps into the cultural zeitgeist by bringing together today's biggest musicians and social influencers from platforms such as YouTube and TikTok in a competitive format. This event celebrates the global appeal of these creators and platforms and the excitement for a new form of entertainment, which is here to stay. The legal team for the event reached out to TikTok regarding the content of the email, according to a spokesperson. YouTube told Insider it's common for creators to be referred to as YouTubers in non-YouTube events. The spokesperson said the company found it inspiring to see the variety of ways that creators are building businesses and continuing to grow both on and off its platform. YouTube also has a creator code of conduct because YouTubers refer to themselves as YouTubers. Like there's no shade in being a YouTuber, I don't think. And so YouTubers refer to themselves as YouTubers, which is why with this kind of creator code of conduct, off-platform behavior can become on-platform issues because you're inextricably linked to the platform. So I think the event will probably go forward. I don't think this cease and desist is going to end it. I think TikTok will say, well, give us some of the money because you're using our logo to advertise it, and that's an inappropriate use of our intellectual property. So can you go ahead and give us a little bit of that? Is it going to a good cause? No, it seems that the good cause is that we want to see all of these people punched in the face, and they've picked creators that people want to see fight one another. I don't think it's going to any cause. I think the money is going to the creators who are lining their pockets from these events that are very, very lucrative. And it seems that these are very, very lucrative. So we'll see. Should we get on? We should be getting on. We should be getting on to case updates from the Triller case. You know, more YouTube boxing. Yep, more YouTube boxing. There are updates to the Triller case. I am sure that you have seen them. I saw a number of you tagging me on Twitter saying, yo, girl, there seem to be updates on the Triller case. What's the what? We will tell you what's the what. It seems that the lawyers for Triller and the lawyers for Ethan and Hayley Klein have chatted because there was a waiver of service. What does that mean? Well, it simply means that instead of Triller having to pay to go track down Ethan and Hayley and personally serve them, like hand them the thing, like you've been served, not like dance battle you've been served, not like you got served, but like actually like you've been served legal papers. And this waiver of service summons indicates, and there's one for each party that's being sued, from Triller Fight Club to TED Entertainment Inc., which seems to be the business entity they've identified for Ethan and Hayley Klein, that the entity they represent agree to save the expense of serving the summons and the complaint in this case, understand that the entity they represent will keep all defenses and objections to the lawsuit. So they're literally just saying we accept service of the lawsuit. We're on notice. They generally have 21 days to answer, but that time can be extended. However, I was watching H3 today. Are they expecting twins or triplets? It seems like they might think that they're having twins or triplets because I missed that part when I was getting into it. I know that she is pregnant, very pregnant, super pregnant, but they were saying they might have twins or triplets, which is going to be a whole thing. I have friends with twins and triplets, not together, different friends. But either way, Ethan, I saw him talking a little bit about this. It seemed to indicate that the attorneys were speaking behind the scenes. I'm not surprised that there was a waiver of service. It's like, your lawsuit is stupid. We'll comply with service and we'll talk to each other behind the scenes and try to sort it out. So I think the parties are probably talking. I think the lawyers for the Kleins and their company have said, you don't even have a date. What are you even doing? We need to just resolve this. And I hope that we'll just see it resolve. This is definitely the type of lawsuit. I don't always give my opinions on how a lawsuit should go. Most suits, I'm like, it's their right to sue. These are their claims. This is what it is. This lawsuit is stupid and poorly written. If they want to write a better lawsuit and actually prove that something's been done wrong, go ahead and prove it. But this But this, no. Nope. No. I hate this suit. Not even with peace and love. With anger and annoyance. With anger and annoyance, I hate this lawsuit to my core. Like it's poorly pled. It seems pointless. I don't know how they're going to prove damages. The people who contemporaneously streamed the fight, go ahead. The people who used it as fair use for commentary, no, sir. No, sir. So, those are my thoughts. Those are the updates. We'll see what happens. Either way, though, H3 still has to pay for lawyers to deal with this. And this is the thing with lawsuits. Anyone can sue anyone for anything. And they still have to pay for this and pay for their lawyer to deal with this. And that can be really annoying and expensive and stupid. But hopefully it will resolve and we will be done with it. They have not resued Mike. They have not resued him. So we will see. That is the update. I will keep you updated if there are more updates. I don't know if there will be, but we've got 2 more weekly roundups. We got Jen Shah and then Tati Westbrook. So let's talk about Real Housewife Jen Shah. Yeah, that Real Housewife. The one who's been federally indicted. That Real Housewife. Jen Shah filed a motion in court for an extension of time to June 14th. It looks like her lawyers are working on some objections. So we should see a court filing from her camp by June 14th. And when we do, we'll go over that. But that's not why Jen Shah has been, gaining the attention of the folks this week. She not only had a GoFundMe put up by her cousin, but then stepped out and like thousands upon thousands of dollars worth of Gucci while this GoFundMe was going on. So because the U.S. Sun has no problems being shady, I'm going to pull them up. Also, my end looks like it's lagging. If I'm lagging, you guys, I'm sorry. It looks like I'm a little laggy on my end. Apologies if that's true. So let's pull this up and talk about Jen Shah. So the Sun is replete with ads. Like it just is. Get your bag, the U.S. Sun. Jen Shah is now stepping out in, not all of the Gucci, but was in the Gucci hat, the Gucci bag, all the Gucci. When this GoFundMe was going on, they've noted that she has ditched most of the expensive stuff. I wonder if it's the same sweatshirt. Do we think it's the same sweatshirt? Could it be? It looks like it's the same color. I mean, is Jen Shah at the point, is this the same day? Or is Jen Shah at the point where she's like, this is on the bathroom floor. This is just what we're doing. So her cousin set up a GoFundMe and asked for $2.5 million. And it went inactive less than 24 hours later. I will tell you why. I think GoFundMe took it down, and I will tell you why I think GoFundMe took it down. Also, in the members only live stream last night, when we were pulling it up, some of the articles indicated that GoFundMe took it down. But I believe this GoFundMe for legal fees went against GoFundMe's terms of service. And I'm going to pull those up in a minute. But her cousin created this GoFundMe and said that she had spent already over $100,000 in legal fees, that Jen needs $2.5 million because, one, there are over 1 million documents in this case that must be immediately reviewed and analyzed by Jen's lawyers before her case goes to trial in October 2021. Yes, and that's part of this pushback for the motions. She has to review, or her lawyers have to review these documents before they can file the motions in June. Like, they are probably working overtime, and that is quite a lot. That the Southern District of New York is the most expensive jurisdiction in the country to defend a lawsuit and hire competent legal counsel. That's true. Legal markets, like television markets or radio markets, are radio markets still a thing? Really? Are they still a thing? I think so. But markets vary by city. LA is a more expensive market for lawyers. New York is going to be a more expensive market. Minnesota is going to be a less expensive market. So it just depends on the city size, the complexity of the jurisdiction, and the competitiveness of the jurisdiction, and then defending a federal lawsuit when you have the weight of the U.S. government behind it takes a lot of money. Lots of money. Jen has to have the economic wherewithal to fight the government's lawyers who have an open checkbook and can spend millions of dollars prosecuting the case. I mean, there are like 11 other defendants. So, and this is the second case. So yeah, the government probably spent a lot of money prosecuting this. For sure. By defending this case and going to trial, Jen's family has and will continue to spend hundreds of thousands of dollars in legal costs. Yes. Yes, you will. Yes, you will. Hundreds of thousands of dollars. The cousin said in just 7 weeks, Jen and her family have spent over 138 in legal fees. Okay, start selling the Gucci, Jen. Like you got approved to be on OnlyFans. Look, get probation to approve a Poshmark. Start selling the Gooch. Just start selling the Gooch. Start up. Fans quickly took to social media to slam the fundraiser. Yeah, Jen doesn't seem to really give a fuck about this case, my opinion. So let's look at what GoFundMe says. GoFundMe says, in the limiting the foregoing, you agree that you're not using a fundraiser for the legal defense of alleged crimes associated with hate, violence, harassment, bullying, discrimination, terrorism, or intolerance of any kind relating to race, ethnicity, national origin, religious affiliation, sexual orientation, sex, gender, gender identity, gender expression, serious disabilities or diseases, financial crimes, or crimes of deception. Whoop, there it is. Tag team back again. Check it, wreck it. Let's begin. Federal indictment's going to be expensive. You can't make a GoFundMe for that though, because financial crimes and crimes of deception. And that's exactly what this is. This is a financial crime and crime of deception. I mean, it is literally fraud and money laundering. Those are the allegations here. So GoFundMe is going to be a no-go on that. Notably, though, she only raised $250 in 24 hours. I'm just saying, I wish her better luck on the cameos. I think like if they did cameos that were also like NFTs, that could maybe be a thing to pay for legal defense. It's like, get a cameo from Jen Shah before she goes to federal prison. I don't know why jazz fans felt appropriate. They just did. Look, I really want to get tickets to go to BravoCon, which is going to be happening right before she's supposed to go to trial on this. I really just. All right. Are you guys ready to move on? Are you ready to move on to the Tati Westbrook case? Look, chat, I know how we feel about KJ, but the rules are the rules. We keep it civil. We talk about the things. I am sure there will be other videos breaking this statement of KJ down and throwing shade. We are here to close and bring to an end the Tati Westbrook defamation lawsuit. We are blessedly done. We are blessedly done with this lawsuit. So, are you guys ready? Are you ready? Let me know. Let me know in the chat. I want to see it. I want to see if you are ready for the end of the world as we know it. It also only feels appropriate. Today, we have come to the close. I opened at the close. We have come to the end of the Tati Westbrook without a crystal ball defamation lawsuit. And I am not a cat. And I am also not Clark Swanson. But you know who is Clark Swanson? KJ's source, who got thrown right the fuck under the bus. The bus then backed up and ran over him some more. So let's talk about this statement. Let's talk about my predictions. And let me just say for the record, I said that. I said that. So KJ released a statement on her YouTube channel. If you want to see it, go watch it. It is also clipped onto Twitter. But if you want to go see it, go watch it. This appears to be the end of the Tati Westbrook defamation case. It appears to be the statement that there has been a settlement. The title of the video is, quote, "We settled." I think by we, she means not herself in the third person. I think she means we, herself, and the Westbrooks. So I think she is putting them together, but her title of her video is "We Settled Our Lawsuit with Tati and James Westbrook." Is it we, her, and without a crystal ball, the company? Either way, we settled our lawsuit with Tati and James Westbrook, our official statement. I think that the statement, to me, it appeared to be read. It appeared that this was a pre-written statement. I imagine and suppose, Emily lawyer speculation based on how these things just work, that this statement was approved by both sets of legal teams, that the settlement was approved by both sets of legal teams after what seems to be mediation and probably almost a deposition style taking of a statement from KJ, wherein she threw Clark Swanson under the bus and gave up all of the information he had given and said, look, this is what he told me. Have at it in the other lawsuit. Now, when we look at the goals here, Clark Swanson is apparently a CEO of a new crypto company, likely has more money than KJ does, my speculation, and seems to be the one that is causing a lot of the problems. If Clark Swanson was in fact feeding KJ information to damage a company that it seems he owes a fiduciary duty to, it's a big problem. And then he sued Tati and James Westbrook for more of a part in the company. He is their business partner. He owns a third of the company. Tati and James own 2/3 of the company. Also, which could have happened, we could have sat down and had the kind of the members vote on this in their, in a formal way, but also Tati and James could have just voted because they have 2/3 of the company, which is what we know from the business partner lawsuit. Can you imagine, let's suppose for a second there was no meeting of the minds with the members of Halo Beauty and, they took a vote with 2/3 board approval or, member approval for the LLC and didn't tell Clark that this was going down. And then he saw it on YouTube. Can you imagine? Can you imagine this? The lawyers in the business partner suit, I'm sure, are on phone calls on the West Coast having conversations about what's going to happen next. So we will be shifting our focus back to the business partner suit to see what happens now. I wonder if it will settle based on the information that has supposedly been provided by KJ, because I can only imagine that what the Westbrooks would want, and the reason that the Westbrooks, supposition that I've said from the beginning, the reason the Westbrooks have done this seems to be either, and I said this when I first read these two suits together, either Clark was getting his information from KJ and suing the Westbrooks based on her reporting, in which case Halo Beauty has to defend itself, saying, no, those statements were defamatory and you shouldn't be suing us based on those statements. Or Clark was feeding this information to KJ, which as I started to see her content, because when I first read the lawsuits, I had no idea who she was. So when I started to see the clips of her lawsuits and all of the people who compiled videos of her talking about her source and the source that broke the lawsuit to her, and then the fact that she said there was a source at the courthouse, which was clearly not accurate or true because it was, e-filed. All of these little inconsistencies, it became very clear that Clark Swanson had given her some information. We never knew really how much. And now we see a statement from her ostensibly saying, I was manipulated by Clark Swanson, and the Westbrooks get what they want if, they get the information on who her source was, which is the only reason to wait 18 months and send 4 cease and desist to try to have a conversation over the alleged defamatory statements. All the statements KJ says she took down, she wiped her Twitter, took the videos down, wiped her second channel. So the statements are down, which is essentially yeah, my bad. I realized how damaging these statements could be, which she said in her apology/settlement statement, and said, yeah, I realized that these statements could be damaging. So she took everything down. She said that the other side took things down, which I imagine was stuff from Salty's Twitter, which if they're going to use her as a witness, of course you would take that stuff down. And the Westbrooks get Swanson and potentially emails between the two of them, statements from KJ, cooperation from KJ, potentially a deposition from KJ, testimony from KJ saying, he told me all of this about them, which Why you don't just do that at the beginning of this whole thing when you get the cease and desist, I don't know. I think it's because KJ sees herself maybe grander in this whole thing. The sense of self-importance seems to be there, and I think that probably hindered the process and maybe cost a lot of money. But at the end of the day, I think the Westbrooks get what they want. They get Swanson, and the statements that they said were defamatory are taken down, and KJ gets what she wants. She gets to say, I was manipulated by Clark. He told me all this stuff. It's not my fault anyway. To half apologize and to go on about her day cooperating with the Westbrooks. She's now subsweeting salts. Apparently they're friends. I'm teasing. That's speculation based on sub-Twitter that I can't see because I'm blocked, but I see it on other sites because y'all screenshot everything. So what do I think? I think there probably is a settlement. This is probably the statement that's going to happen. This statement seems to be drafted and approved. The video was probably drafted and approved down to the thumbnail and the title and the contents. There's a lot of jump cuts in it, which also indicates to me somebody reading something and making sure that it's very precisely said. So maybe reading it and extrapolating, cutting it out and trying to narrow it back to the red statement. That's how I viewed those jump cuts. But again, that's my supposition on it. And I generally think it's a good thing for all the parties. They're not going to waste the money. The real money issue is going to be the business partner lawsuit. Always was going to be. This was never about money with regard to KJ. So it's done. It's done. No more Brown. No more sassy footnotes. I am sure we will have salts in other lawsuits. We will keep an eye on salty suits so that we can follow them. And I'm sure he and I will have a lawyer chat at some point. I have not asked yet, but we will lawyer chat, not about this case, but about the practice of law, the art of the sassy footnote, and all things. So let's see what you guys have to say, and then we'll get into our content for this evening. I should also say, do the YouTube-y things if you're here on the YouTubes, like the thumbs up-y things and the subscribe-y things. We're almost at 130,000. I think we might need a little more color in the hair when we get to 130,000. Maybe we do some galaxy color, a little bit of blue, a little bit of pink, a little more purple. Maybe. What do you think? I think we should. SC says, I'm so happy this lawsuit lasted what feels like 900 years. Yes. Yes, it did. Over the holidays. This lawsuit lasted 100 million years, but everyone now knows what jurisdiction is. And everyone's looking at stuff going, is there jurisdiction? International shoe. I am invoking international shoe. I think we all called it. All of us were like, Swanson's the source. Why doesn't she just say, I had a reasonable belief that these statements weren't defamatory because I had a source? I don't know. Hubris. Hubris is the reason, I suppose. So this is going to be very, very interesting to see it go forward. Wonder how much of a good spanking the jury judge will give Swanson now. Her selling him out feels anticlimactic in this shit show of a Lifetime movie. Yes, slightly, but we haven't seen what will play out in the business partner lawsuit. So it might explode over there. Are we going to see the Westbrooks like cross-claiming Clark Swanson for breach of fiduciary duty and defamation and other things? Maybe. Will we? I don't know what we'll see. So this part is done, but it's not done because the business partner suit's not done. And if KJ did give up information on Clark that the Westbrooks are going to use, there's going to have to be at least a deposition, sworn testimony, potentially testimony at trial. So it's not like all the way done, but the parties all have to play nice together, which is part of why we saw a joyous statement, which is why I don't think we'll ever see the Westbrooks address this and maybe the business partner suit, maybe when it's over, which is why I think we're seeing people playing nice together on Twitter, is because we have to. So it's just. KK Webb, how long do we think before they file a countersuit against Swanson? I don't know, but when they do, we will cover it. Because there's still a lot going on. I'm going to get to a few more of these super chats. Welcome as a channel member. And I am sure there will be other videos. I am sure the lovely Drama and Opinions will have a video. Truth Sleuth will have a video. I am sure there will be other videos. And they will have all the sassy editing and the clips of the things that KJ has said, the clips of why a lot of us thought that it was Clark from the beginning based on the things that she said on various channels and in her own content. So I think there will be lots of videos kind of covering and breaking that down. But for our purposes, this seems to be a settlement between the parties. There were days of mediation, we now know. We now know that there was a source which can give a defense to most of those defamation claims. I don't know if it gives a defense to the misreading of the lawsuit with regard to James Westbrook's mother, but to reach the greater goal, sometimes it's like you can win the battle and lose the war. I feel like this is a win the war for the Westbrooks and concede some of the points in the battle to give KJ something that she feels that she wants, which is going to be perhaps the ability to blame someone else for her, for the things that she said. And if he was feeding her that information, was she right to believe him and not verify the source? I mean, I'd love to know your thoughts. Kira says, if Clark was feeding KJ info, well, she said he was. So we're not going with if anymore. We're going, KJ said this is what happened. I mean, do we believe her? I believe that she provided enough that the Westbrooks believe that it's credible. Otherwise, there's no point in settling. And I believe that probably came in either, I believe she mentioned emails in her statement, but that would have come in documentary evidence that they could verify, because they're not going to settle this and bank on something that they can't, cash in. You want to make sure the chips are real. Considering that Clark is James's former best friend, it's a horrible betrayal. It is a horrible betrayal. And if it is true, which I have no reason to believe it's not, I thought it was Clark from the beginning. I think KJ probably would have done herself a lot more favors if during the cease and desist, she had called a lawyer and said, hey, they're suing me for defamation, but I got all this info for a source that's now suing them. Can we just tell them what we know and just like piece out of the thing? Like, how do I yeet myself out of this as quickly as possible? Like, I have no purpose in this. I'm not going to be manipulated in this. Tell them what they want to know and let me out. Like, let me go. So, Serenity says, why do I feel like this isn't the end of KJ, Tati, and Swanson? Well, because the business partner suit still has to happen. But it's always nice to see that the supposition from the beginning that a lot of us had is actually what was happening. And there's a little bit of, oh yeah, it kind of played out the way that I thought that would play out, because at the beginning it didn't really make a lot. And if you've seen the old videos, you'll see that this was the supposition since the beginning. Because it didn't feel like it was unconnected. It all felt like this was very connected. I missed a few super chats, so I'm going to pull them before I move on to the other topics for the evening, and then we'll get back to questions. They screenshot everything is an understatement. It is. Y'all screenshot everything, but it just is. So Azaria says, if Tati releases Text Neutrals Volume 2, she should make a brown fecal shade called Swanson and the glitter metallic. I don't know if Tati's that shady, but it sure would be funny. But I don't know if she's that shady. But maybe, I mean, is Tati vindicated at this point where she's like, no, I was being defamed? But then is KJ also vindicated with, I didn't think it was defamatory because the business partner would know these things and I was relying on this source that seems to have inside information. So it was reasonable for me to believe that he was feeding me true information. Though if he has beef with them and is about to sue them, maybe there were some ulterior motives there. But are both sides vindicated with, hey, I was fed this information, and hey, our business partner was undermining us horribly and trying to damage the business when he had a duty not to do that. I don't know. What do you think? I think this, when you look at a settlement, I think both sides in this get something that they want. And I think that is what makes a settlement possible, is that both sides are able to get something that they want. And at the end of the day, the Westbrooks were never going to get money out of KJ. It never seemed to be the thing that was going to happen. So let me round up a few of these super chats that I missed, and then we will go along. We will move along. Mike Roel said, this is not malicious at all, but I would pay to see Gabby Hanna get punched by Tana Mojo. I mean, I think Gabby Hanna would gladly get paid to get punched by Tana Mojo. Taylor McHenry said, first live, found your channel when Christine from Simply Nailogical mentioned you. Thank you. Isn't Christine lovely? On the podcast, and have been binge watching the Tati drama since. It's a lot of drama. And now it has a resolution. Batul said, my friends and I made designated group nights to watch your live streams. Thank you. A bunch of med students who love your legal commentary. Well, if we have any medically related cases, I will try to do them justice for sure. But thank you. I love that you're having a girls' night, friends' night. Cheers to the med students. And I can't imagine what it's like to be in med school in the middle of a pandemic. It must be really fucking stressful. So cheers to you for doing it. Let's see. Alicia L said, is there anything that Clark isn't in? Oh my. Azaria said maybe Without a Crystal Ball versus Tati was simply the prequel. I mean, yep. It was always going to be one of two ways. It was always going to be either he's relying on her information and they're saying her information is defamatory, at which case the company has to defend against it, or he's feeding her information, in which case they need to know about it. For the Westbrooks, it's kind of a big win because now they get this information early on in the business partner lawsuit, where if they had to go to trial with KJ, that could have taken a year to 2 years. They would have had to go through depositions, which would have been expensive and time consuming, especially considering how many videos KJ put out, and going over all of that in deposition would have been so much money. So the Westbrooks and KJ have saved themselves hundreds of thousands of dollars in doing this, and everybody gets at least something that they want, it seems. Miranda Joy said, question, is there any proof that KJ is telling the truth, that her source is Clark Swanson? She said in her statement, the statement seems to be a red statement approved by counsel. That would have been vetted in the 2 days of mediation. There would have had to have been enough that Saltz and the Westbrooks felt that this was credible information that they could actually move forward with in their lawsuit. So, and I think that catches me up on all of the super chats. So we're going to move into some of the other stuff, and then we will get back to questions at the end. Otherwise I will circle with questions forever, and we can get back to this. Chat, I appreciate you guys asking questions about what is happening and keeping the personal opinions out of it when we talk about polarizing creators that have come for so many of us. And I appreciate that. Christina said, a bit off topic, but I'd love to hear your opinion on the cheerleader Snapchat free speech USSC case. I think it would make a great Emily Show episode. Thank you. It is on my list. I have to get to Dave Ramsey first, but I will be talking. There will be more and more cases that touch on free speech coming up, and we will absolutely talk about that. So y'all, this has been a lot. Oh, also, did I tell you guys yesterday I was in a Twitter Spaces room with the lawyer cat judge. He was absolutely lovely. And we had a nice little chat on Twitter Spaces about the lawyer cat moment in time and humanizing the legal profession and access to justice. It was really a cool conversation. So, it was really fun. So, okay, we're moving on. And then I'll come back to questions, chat. I promise. Do y'all want to talk about Hayley Paige first or Girardi first? Let me know and we'll decide. Also, there's over 3,000 of you here, so go ahead and do the YouTube things like subscribe. If you don't follow me on other social platforms, do that. Twitter, Instagram, I'm at the Emily D. Baker everywhere. If you're in North America, the text crew is available to you. Textemily.com will get you there. The text crew got to vote on the colors tonight. If you're not getting texts, go ahead and text me and tell me you're not getting texts, and I will try to fix it. And okay, let's see. I'm going to go through the chat. Girardi, Paige, Girardi, Paige, Girardi. I feel like I said Girardi more. Paige, Girardi, Paige, Girardi, Paige, Girardi. Oh, lot Girardi, Paige, either one. All right. That looks like a lot of Girardis. So we're going with Girardi. We're going with Girardi. We have ruled. Let's move into... We're going to have to do some background on this one before we get all the way into it. And it is hot in my office at the moment. Do you see it? Do you see it? This is why we're not drinking whiskey on stream, because A, I would be sweaty, and B, I'd probably be drunk. So kombucha and vodka. Let's get into the Girardi suit. I'm going to catch you guys up. We're going to do a brief road so far. Brief. Tom Girardi, in the new Hulu trailer called The Hustler, and his wife Erica Jane in the new Hulu trailer called The Housewife, are in the midst of a whole lot of legal shit. There are lots of episodes on this channel breaking it down. Tonight, what we are talking about is the bankruptcy trustee's response to Erica Girardi's lawyer's objection to the bankruptcy trustee's motion to appoint legal commentator and Erica Girardi Twitter questioner Ron Richards as special litigation counsel to the bankruptcy to go after Erica Girardi for potential loans that were made from Girardi Keese, the law firm, to Erica Girardi, or EJ Creative, her business entity. In the Edelson PC lawsuit, it indicated that there may be $20 million in loans to Erica Jane's company made from Tom Girardi's law firm. Because the law firm is in bankruptcy and Tom Girardi as a person is in bankruptcy, the bankruptcy trustee's job is to find the money, bring it back, and redistribute it to the creditors who are owed the money. With regard to the law firm, that is mostly legal lenders and clients who didn't get paid. So it's like, hey, baby, I got your money. Hey. Yeah, that. The bankruptcy trustee is like, show me the money. Hiring Ron Richards to go after Erica Jane with regard to the law firm's money is what they are trying to do. There's a hearing on this coming up on June 8th. There's also a Brittany hearing coming up. There's lots of hearings in June. So there's a hearing coming up on this. Erica Jane's attorneys objected. Your Honor, he cannot. It is a conflict. We feel there's a conflict. Also, he said shit on Twitter that we did not like. If you want to look at that breakdown of the legal document, I broke it down in another one. The Twitter stuff for me may give the appearance that the bankruptcy court may not like, but I was more concerned about a potential conflict because he is representing other debtors. They said going after similar sources of funds. So let's take a look at what the bankruptcy trustee has to say about that, because they're saying, no, that's not it at all. Yes, this is 45 pages long. No, we're not going through the entirety of the thing. There is lots attached to this, so we will just go through it quickly. They are trying to appoint Ron Richards. The court should overrule the opposition is the position here from the trustee. Primarily, the opposition is fatally defective and should not even be considered. Do not consider it, as Erica does not have standing to oppose the application. Now, it's my understanding that anyone can raise an objection, but okay. She makes no attempt to explain why she should be heard on the application. Well, you're trying to go after her, but I understand that. For this reason alone, the opposition should be overruled. I don't know if going after it on a procedural ground is what I would do, but if they are firm in their procedural ground, we'll see. They say, as to the application itself, Erica asserts two bases for its denial. Both fail. First, the creditors represented by the Richards firm are not pursuing fraudulent transfer claims that belong to the estate. That is the basis of the potential conflict. And if there's not a conflict, then the Twitter stuff is probably not going to be enough. Now, it might be enough to annoy the bankruptcy judge. And the bankruptcy judge could say, to avoid an appearance of impropriety, we're not doing this. I don't want this smoke. What we're not going to do is this. There are lots of other lawyers in Los Angeles. Find one of them. We're not doing this. But the bigger issue is an actual conflict, which is what Erica's lawyers allege, and what the bankruptcy trustee is saying, no, that doesn't exist, didn't happen. So let's see what they say as to why. The trustee and the creditors represented by the Richards firm have agreed that only the estate will pursue fraudulent transfer claims. So it sounds like there's already an agreement that the debtor that Richards represents is not going after the same money that he would be tracking down for the estate, because there could be a conflict there if he is representing two different parties to go after the same pool of money, which you can't do. If it's like, how would you represent both interests fairly? Right. You can't. They're saying, right, but not a problem. This agreement, stated on the record and recognized by this court's order, eliminates any actual conflict of interest. Well, that should have been maybe mentioned in the other motion if the court has already ruled on it. Second, the trustee seeks to employ the Richards firm as special litigation counsel under Section 327E. Employing the firm under this section limits the inquiry as to whether the firm holds an adverse interest. So they're saying conflict, irrelevant, adverse interest is all that matters. Erica's disagreement for the limitation in Section 327E, namely her failure to argue how a possible claim objection presents an interest adverse to the estate, is an unrelated potential fraudulent transfer action, warrants denial. There is no actual conflict, and the Richards firm does not hold an adverse interest with respect to the matter for which they are employed. Erica's request for a gag order is not properly before the court. Erica's lawyers are like, look, at least if you do choose to appoint Ron Richards, the Twitter shit, though. It's a summary. That's my summary of it. The Twitter shit. We should not be talking about it. But limiting somebody's ability to speak, because there already are professional rules about what you can say, and you can share information, factual information about a case. I imagine the shading of what Erica's up to would maybe limit if he was appointed, just in an effort to make things go more smoothly and not have the judge get annoyed. Background: this is the underlying litigation that Erica's attorneys say is an issue. On December 9th, 2020, this is well before the motion from Erica's counsel was filed, which was just last month. The law offices of Philip R. Sheldon, APC, filed a complaint against Girardi. In this case, on December 16th, the law offices and Robert P. Finn, collectively plaintiffs, filed a First Amendment complaint. The First Amendment complaint, plaintiffs assert a cause of action to recover fraudulent transfers. On January 29th, the Richards firm filed a notice of association of counsel on behalf of plaintiffs, meaning he was coming in to represent. Essentially, as disclosed in the trustee's application, the firm is currently counsel for plaintiffs who claim to be creditors to the estate. The removal and remand of the Sheldon litigation, when things go into bankruptcy, other litigation stops wherever it is and comes under the umbrella of the bankruptcy and gets sorted out in the bankruptcy court. March 5th, Lyra filed a notice of removal to remove the Sheldon litigation to this court. The litigation was assigned case number that. On March 9th, the court entered an order setting a status conference and ordering the parties to show cause why the court should not abstain and remand it. The court then set a status conference, procedural. The parties further stipulated that the dismissal of the debtor would have no effect on plaintiffs' rights to enforce any alleged claims they purport to hold against the debtor by filing proof of claim in the debtor's case. That's this case. On April 16th, that was just recently, plaintiffs filed a motion for remand in response to Lyra's notice of removal. This is procedurally thick. A hearing on the remand was scheduled for May 11th. In response, the trustee filed the Chapter 11 statement of non-opposition to the motion. The trustee was cool with it. In the statement, the trustee informed the court that based on plaintiff's agreement, that they would not pursue the fraudulent transfer claims. So back in April, it was agreed upon that in the underlying litigation of attorneys that said they were owed money by Tom Girardi, they were just going after the funds of the estate. They were not going to continue to go after Erica Jane for any money that might have been transferred from the law firm to her, which would have been the conflicted monies that are being discussed. At the hearing on the remand motion, counsel for plaintiffs confirmed that the fraudulent transfer claims asserted by plaintiff in the Sheldon litigation belong to the estate. Mr. Evanston, trustees counsel, our only request is that plaintiffs counsel confirm on the record that the fraudulent transfer claims will be pursued by the estate. Richards, that's correct, Your Honor. We are not pursuing any of the fraudulent transfer claims. Those are just going to be pursued by the estate only, meaning only the bankruptcy estate is going to go after any fraudulent transfer funds. And then if the bankruptcy estate gets those fraudulent transfer funds back from EJ Creative or Erica or whoever, then that would be dispersed out based on the order in the bankruptcy court and based on the various agreements for settlement within the bankruptcy. So it would get doled out to the various debtors. They attached a transcript saying that from the May 11th remand motion. On May 13th, the court entered an order granting the motion, meaning the case was being remanded, and also stated that counsel for plaintiffs also reaffirmed that plaintiffs would not be proceeding on any fraudulent transfer claims, included but not limiting to the 6th cause of action in the First Amendment complaint, that the fraudulent transfer claims belong to the bankruptcy estate. So the bankruptcy court has also re-acknowledged that that issue is not an actual conflict because they're not going after the same pools of money. Interesting that it was included by Erica's attorney, because it seems like if they had gone over everything in the bankruptcy court, because these were in the bankruptcy court, that they would have seen that before they filed. Because I think the timing is there in May. Hold on, let me pull I don't think I have the date that was filed at the top of my fingers, but it was after that because it was filed just before the video I did on it, which was at the end of May, but the timing may have been close on that. Either way, if it's not an actual conflict, it's just not an actual conflict. It is or it is not. The memorandum of points and authority is the law that this side is arguing applies to the thing. But again, if there's no conflict, then there's actually no conflict. And if they're not going after the same pool of money, there's probably not a conflict. Erica has no standing to object to the application. I mean, in the bankruptcy, anyone can object, and they are going after her. And she might also, I don't know if she's filed a notice, and I don't think the date has come yet to file a notice of creditor, but she, as the estranged spouse, might be owed money from the law firm too. She might actually also be a creditor in this, but we'll see. Erica does not have standing to object. A party standing in a bankruptcy case is governed by the person aggrieved standard. A person aggrieved is one whose pecuniary interests are directly and adversely affected. Well, her pecuniary interest could be directly affected if she, as part of her marital estate, invested into the law firm and loaned money to the law firm expecting that the law firm would pay it back. She, as a spouse to Tom Girardi, because they are still married, they are not formally divorced yet, could actually be a creditor. I mean, she could have a pecuniary interest. They're not seeing it that way, but she could. She probably should have showed that, though. I don't know if she needed to, though. Erica has not made any showing of how she is a person aggrieved with standing. Here, Erica has not filed a proof of claim. Fair point. Or highlighted any pecuniary interest that would have adversely affected by an order granting the trustee's application to employ the Richards firm. Here's the thing that's interesting. There's like a game of chess that's going on of, you know, where is the money? Where is the money owed? So filing a proof of claim might tip a hand somewhere else. So I feel like all of the stuff with regard to Erica in this is a tightrope for sure. But she would have to say that she has an interest. I mean, she could have an interest, but fair, she has not said. She has said with regard to the bankruptcy in the personal side of things, Erica cannot establish standing simply because she might be a defendant in a fraudulent transfer action. Well, she might know if she is or if she isn't. Maybe that's part of the objection filed. I think she was bringing it to the court's attention. By the way, Your Honor, I refer you to Twitter. Courts have routinely held that status as a defendant in a fraudulent transfer case does not confer standing. Fair. And this is the case that they're citing, holding that the debtor's wife did not have standing as a potential defendant to appeal in order reopening the case so that the trustee could pursue fraudulent transfer claims against her. I think this circumstance is a bit different because of the direct interest, but the law that applies might be read the same way by the court, holding a second case holding that the debtor's wife did not have standing to appeal the court order granting the creditor relief from a stay to prosecute. Then they get into the Ninth Circuit law on the same thing, talking about no standing. In some, they say Erica, as a mere potential defendant, does not have standing to oppose the application. The court can disregard the opposition on this basis alone. They're saying, Your Honor, yeet. Like, don't waste your energy, Your Honor. Don't waste your energy. Just no standing. Throw it out. Just don't even bother with the rest of it. Just, she has no standing. Don't even hear it. Move along and appoint me so I can go, well, trustee, appoint this firm so that they can go and find whatever monies may be there. The fraudulent transfer claims will only be pursued by the trustee and do not create an actual conflict or an adverse interest. And we talked about that up above. If the firm is not going after two pools of the money, it's not going to be an actual conflict. That's just not going to be. So I don't think there will be a response. I just think they'll respond to oral argument. The potential claim objection does not constitute an actual conflict or an adverse interest. Yeah, we already covered. I think we have, well, for our purpose, covered whether or not there is an actual conflict here. They talk more about the case law that governs it. I appreciate the thoroughness. I'm sure the court will too. They get into talking about why, if Erica's arguments are accepted, it would actually undo the way that the law is meant to work, and that it's not unusual for a trustee to retain special counsel that also represents a creditor. It's expressly permitted in the bankruptcy code, and Erica acknowledges that in Tom Girardi's individual case, she does not oppose the trustee's application to employ special litigation counsel that represents certain creditors. Right, because that litigation counsel wasn't talking about her on Twitter. This all has to do with Twitter. The reason there's an objection here, I think, Emily thoughts, is because they don't like the way Ron Richards talked about her on Twitter. I think that's literally all of it. But if there's no actual conflict, it's not really pretrial publicity if she's not a party yet and if he's not retained yet. So, I mean, I understand that her counsel might not like it, but also, yeah, you're allowed to say things about a case. There are boundaries to that, but I did a podcast where I broke that down and my thoughts on it. And I don't think, though I think some stuff is gray and some people might be like, I don't like it, I don't think it crosses those lines. I really don't. The request for a gag order is improper. Erica's request that the court issue a gag order, they might just issue a tweet order limiting the speech of Mr. Richards, is improperly raised. This request is completely irrelevant to the standard for employment set forth in the application. Moreover, the issue is not currently before the court and should not be raised in an opposition for the first time. They don't address the Twitter at all, which is really interesting because it's such a big part of the other stuff. I wish that they had just also said that's irrelevant. It's not improper pretrial publicity. It has literally nothing to do with whether Ron Richards can actually represent the trustee. And it's kind of irrelevant, but it's just not addressed at all. And maybe that's what the court appreciates. I'm sure the bankruptcy trustee is well more familiar with the bankruptcy judge than my ass is. But I would have liked to have seen it addressed just a little bit, just a little bit, but they didn't. The actual conflict was the bigger issue anyway. Let's see what they attached. They attached the stipulation that was filed the 25th of March. So that's the stipulation saying, yes, this is what's happening that they referred to above. They attached the order approving the stipulation from March 26th, which Erica's attorneys could have found. It's part of this case file. So maybe should have seen that, I think. And then they posted, what is this? The other motion, not the other motion. The non-opposition to the motion for remand that they referred to, and then the transcript of that court hearing going over it. So, I mean, they've pretty thoroughly vetted that they don't see an actual conflict here. It'll be interesting to see what the court does. I imagine if standing, I don't think we need this whole hearing. And the order granting the motion for remand. I think that if the court wants to thoroughly do this, they will probably address if they're standing or not, and then say, even, if they find no standing, say, even if I did find standing, I would still find no conflict because of this. It would make it cleaner to just kind of put this to bed. So we'll see if Ron Richard gets appointed as special litigation counsel to go after Erica Girardi for alleged fraudulent transfers. If there are any, part of that hiring is to start tracking them down and see if they exist. We will see. The other law firm's already been appointed in the personal bankruptcy, so I do still think we'll see Erica Girardi being sued by special counsel for the bankruptcy trustee in at least one of these cases. I imagine that will come soon. What will probably happen sooner is we'll see more about this on Housewives, and we'll see that Hulu documentary, which I am watching with great interest as all of this continues to unravel, because I have never seen anything like it. I think there will probably be a Lifetime movie at some point, another documentary. This case is fascinating. I have never seen a clusterfuck like this. It's just, these bankruptcies are wild. And I'm very interested to see, in the personal side of the bankruptcy, the Axe firm going after what Erica is arguing are gifts. We will see if they say that they are gifts or not. And that's going to include the jewelry, the clothes, any art. It'll be interesting to see, and we are going to keep up with this one. But let us move along before we get to questions and court of public opinion to Miss Hayley Paige. So take a moment to take a drink and do the YouTube-y things. I should tech. We should have a do the YouTube-y things thingy. We're going to have lots of thingies that we play. I love getting to hit the button and play things. It makes me so happy. Look, it makes me so happy. The court of public opinion one makes me so happy. I love getting to hit the button and do things. Do the YouTube-y things. Like, subscribe, do the things. We'll make our own little swoosh at some point. We will. Have a drink. Cheers. And then we'll get to questions. All right. Hayley Paige. Latest court ruling, defeat, shade. You know how we feel about Hayley Paige. Look, she's made a lot of statements on Twitter. We have not covered her employment claims yet. I was going to do that last Friday. Then I had to move Friday Night Live. We will cover that in another live. We will get its due. Fair's fair. Hayley has said that the work environment was less than ideal, that her boss acted with less than propriety, and those are her allegations, and we will cover her allegations because we definitely have covered the allegations of JLM against her, and again, fair is fair to cover everybody's court documents. We just haven't had time to get into it, and then this happened. The court issued a ruling on June 2nd. Let's do a road so far real quick. Real quick road so far on Hayley Paige. Hayley Paige is a wedding dress designer that worked for JLM Couture. As part of her employment agreement, she sold the rights to her name, all of her name, in connection with the bridal and evening wear industry. When this employment relationship broke down, she is still under contract to work for them. She doesn't really have an out to that contract, and she has stopped working for them. She was trying to renegotiate with them. They were like, we're not going to do that. We can extend your contract. And so we did. She has stopped working for them. They sued her. She's made statements on Instagram. She countersued them. They roped her fiance or husband, I think husband, into this thing. They're also suing her for defamation over statements made on the Instagrams. And in all of that, there was a motion for a preliminary injunction with regard to the Hayley Paige Instagram account, Miss Hayley Paige, part of the trademark names that she sold. And they gave the Instagram account, the court gave the Instagram account to JLM, her employer, saying This is a business asset. And during the course of this litigation, the Instagram account with over 1 million followers goes to JLM. So Hayley Paige lost her Instagram account that she argues is her personal account. JLM says it's a business account. JLM said, what you can't do with our business asset is have brand deals that you're benefiting from selling choice salad dressing and shit. You cannot have brand deals on our business account. It infers an association between our business and other businesses that we did not approve. Hayley said, yeah, but that's my Instagram account. And what I can do is what I want. And the court said, nope. That account is going under the control of JLM during the course of this litigation because we believe JLM has a ability to win on the merits. I agree with that statement based on the employment contract. It doesn't mean Hayley can't win on some of her employment claims. It just means with regard to who owns the Instagram account, which is what this case is really mostly over, I think JLM's going to win on owning the Instagram account because they own the rights and they built it as a work asset and she was employed for them when she started it. So then she went ahead and said to the court, can you please reconsider? I think that I could win and I'm asking you to dissolve the temporary restraining order, give me back my Instagram account and that would be really cool. That's a really dumbed down version of her motion. Well, the court ruled on the motion and said, negative, ghostwriter. The pattern is full. What we're not going to do is undo the preliminary injunction that I ordered. I'm not going to reconsider myself, and I don't think you have a chance to win on the merits. So the court has now twice said that they don't believe Hayley Paige has a chance to win on the merits with regard to this issue. That doesn't impugn the employment side of the lawsuit. It just gets into you sold your name. The Instagram account was created in the course of your employment, and let this be a lesson to all creatives anywhere. You can sell your name. It has happened time and time again to creatives. It doesn't mean it might not feel like it sucks, but it doesn't mean it's illegal. You just don't like it. You don't like the result. The analogy I keep making in this case is it's like buying a house and then remodeling the shit out of the house and adding a pool and a second story and making it fabulous and beautiful and like bringing in the crew and making it a home makeover to the stars. And then the original owner comes back and is like, hey, love what you did to the place. That's my house. Can you go ahead and give it back now? Because when Hayley Paige started with JLM, she was the house that was being remodeled and then became famous through her work with them, through being on Say Yes to the Dress, which she got because of her work with them. The Instagram account she started because of her work with them. She couldn't have known what social media would be when she signed that employment contract. She started her Instagram in 2012 as part of her employment with JLM, it seems. She says it was personal, but it seems that it was mostly business and part of the business marketing strategy. And they put in money to building that account. But in 2012, it's really hard to conceive that in 2021, you can make hundreds of thousands of dollars for posting shit on Instagram. In 2012, if you go back in my Instagram, you'll see me posting like media vans waiting to film Lindsay Lohan entering court and shit. Like none of us knew in 2012 what Instagram would be in 2021. And we couldn't. But that doesn't undo the contract just because we can't foresee the future. Creatives know that names can be sold and that creatives can regret it. We know that it happened to Prince. We know that it happened to Bobby Brown and Kate Spade and Halston and others. This is not unknown. We just aren't liking the result at this point. So memorandum opinion and order from the court in the Southern District of New York. Back to the fine Southern District of New York, apparently the most expensive place in the world to defend a lawsuit. It's hyperbole. It's hyperbole. It's a reference back to Jen Shaw. You got it. You're with me. Before the court is defendant Hayley Paige Gutman's complaint, motion to dissolve the injunctive relief provisions of the court's March 4th, 2021 order and motion for preliminary injunction. Defendant Gutman argues that the court should dissolve, undo, unwind the preliminary injunction in light of facts that existed. Shade. They existed at the time, but were not presented to this court. Look, man. Nope. Prior to the issuance of this injunction, specifically, Gutman contends that the injunction should be dissolved because JLM breached the party's employment contract. They suck. because JLM sucks is the argument here, by canceling Gutman's health benefits as of December 31, 2020, and failing to pay her any base or additional compensation under her contract for the year 2021. Well, they did extend her contract, but then she stopped working. So I understand the pissing match going on with the money. I get it. And she's like, you breached my employment contract because you canceled my health insurance. And they're like, you breached your employment contract when you stopped coming to work and doing anything under the contract. The thing is, I hate these force extend provisions. We saw them in the Kanye West contracts too. The provision for JLM that she was negotiating, she was trying to negotiate a better contract, but there was a provision in the contract that allowed JLM to say, no, we're extending this without her consent. So they could force extend the contract, essentially. She had agreed to that in her contract negotiations. But when the relationship goes south, it feels really shitty to have somebody be like, no, you still have to come to work. Cute. Thanks. Our contract says that and we're enforcing it. But we've seen this happen to musicians over and over and over. Kesha also comes to mind. I don't love these provisions, but they're currently still allowable because you negotiate for them. Note, not legal advice. I'll get back to this in a second. Note, understand how your contract can be extended. And if you have any say in that shit, if you ever sign a contract, talk to a lawyer about that shit. Know that. Because what you don't want to do is be like, I would like to leave now. And your boss be like, oh, adorable, but you can't. Separately, Gutman moves for reconsideration of the preliminary injunction order, arguing that it is clearly erroneous insofar as it grants JLM what Gutman contends is an overbroad injunction against competition. I don't know what that was. Something just floofed. Against competition, finds that irreparable harm to JLM is likely absent. An injunction granting JLM control of the social media accounts. JLM was like, no, you're going to keep doing brand deals, which could irreparably harm our brand. We can't just give you the Instagram. You could just delete everything and get rid of all the followers and spread lies about us. JLM was very concerned. The court reviewed carefully the parties' written submissions and heard oral argument on June 1st. For the reasons stated below, the court denies in its entirety the motion to dissolve and denies in its entirety the motion for reconsideration. The court does, however, modify two provisions of the preliminary injunction order for the purpose of clarity. Let's see what the court says. I've already recited the facts. I appreciate how clear the court writes here. I appreciate how clearly the court lays out the law. We've talked about the facts in a sassier way. The court is very clear with the facts here. And the court talks about the fact that the contract negotiations were lengthy. It's not as if it was like, here's this employment contract, please sign. The court specifically says in this and the other one that these were lengthy contract negotiations. So this is bullshit on Instagram with like, I didn't have a lawyer, I didn't know. The court is finding lengthy contract negotiations, not you just signed whatever was put in front of you. My empathy wanes. As part of these negotiations, Mr. Murphy, JLM's chief financial officer, sent Gutman a letter dated July 24th, 2019, stated JLM would retroactively increase her base and additional compensation beginning the fiscal year 2019 as a gesture of good faith during the contract discussions, and that Murphy was looking forward to us strengthening our longer-term partnership with an agreement that supersedes the 3-year option to exercise. That's the option to, as I call it, force extend. I'm sure they don't all see it that way. So they do talk about the lengthy negotiations. Gutman asserts that by failing to pay compensation and benefits allegedly due to her, JLM has materially breached and repudiated the contract, electing to treat the contract as terminated and is not entitled to injunctive relief to enforce the contract's provisions. The motion to dissolve the injunction, it talks about the law, and then the court goes on to say, upon a motion to dissolve a preliminary injunction order, a court should typically consider only new evidence. The Second Circuit expressed what that was. Here, all the facts proffered by Gutman were known or available to her prior to March 4th, 2021, the date which the preliminary order was issued. You lose it, use it or lose it. You didn't use it. you lose it. It's not new evidence that came up since the preliminary injunction. New evidence would be things that came up from the time of the issuance to now. That's not what happened here. It was just not brought, but it was not new. Continuing on, the court said that Gutman's legal arguments fail on their merits. Merits, not on the procedure, on their merits. There is not merit to these arguments. Gutman argues that JLM failed to perform its duties. The court is not finding it. When confronted with a repudiation, the non-repudiating party has two mutually exclusive options. They may A, elect to treat the repudiation as an anticipatory breach and seek damages, or continue to treat the contract as valid and await the designated time for performance before bringing suit. So this gets into, again, whether JLM breached the contract and what her options would have been under it. Here, Gutman argues that because JLM did not pay her or base or additional compensation and terminated her benefits after she communicated her resignation, that the court must conclude JLM elected to treat her resignation as an anticipatory breach of the contract. JLM maintains that it has continued to perform and that it has neither repudiated nor breached the contract. So she tried to resign and they're like, no, you still work here. So they're saying it's not a breach. So they're saying that Gutman did not refute in her reply or at oral argument, respond meaningfully to JLM's assertion that the contract's conditional nature, at least with respect to the base compensation and benefits. Instead, in her reply submission, she simply asserted in a conclusory fashion, what judge do we sound like now? Triller. Triller. That there is no question that JLM's failure to pay her compensation and benefits is a material breach. So the court's saying what you didn't bring were facts. What you did bring was conclusory statements. And what we're not going to do is listen to that. Gutman, who has performed no services for JLM since December 2020, clearly has not carried her burden of demonstrating that JLM failed to perform a duty that was owed pursuant to the contract. You did this, Hayley. You did this, the court says. You stopped working before they stopped paying you. So what was the expected outcome here? JLM also asserts that it's not obligated to pay Gutman additional compensation because Section 3 of the 214 amended contract added references to specific product lines and she's not performing, essentially. They talk about the oral argument a little bit more and said that JLM's position is contrary to the clearer meaning of the contract because she was still able to continue her duties, but she wasn't because she resigned. On the record, Gutman failed to demonstrate that JLM has elected to treat the contract as terminated by her resignation, and the election of remedies doctrine thus does not compel dissolution of the injunction based on Gutman's belated, the court is not having it, belated arguments concerning provision for her compensation and benefits. For all the reasons stated above, Gutman has failed to show a material change since the issue of the injunction, and the order that demonstrates the injunction is no longer justified. Same with the motion for reconsideration. The court's like, I'm not reconsidering. I'm not dissolving. I said what I said. I said what I said, and we're not doing this. Let's take a look at the court's refining of the preliminary injunction and talk about what the court has refined. Accordingly, paragraph 3B of the preliminary injunction order is modified to read as follows. Until August 1st, 2020. This is the court, as I keep interrupting myself, and I have cats wandering under my feet. The court is literally going, I said what I said, and if it's not clear enough, let me crystallize it for you. And I think this actually makes it worse for Hayley Paige. Hi, Fred. How do you feel about Hayley Paige? Are you pondered? Are you having it? Are you not having it? What's going on? Do you want to read it with me? We'll read it together. Until August 1st, 2022, or such earlier date as may be specified in a further order of the court, directly or indirectly engaging in or being associated with, whether as an officer, director, shareholder, partner, employee, independent contractor, agent, or otherwise, any person, organization, or enterprise which engages in the design, manufacture, marketing, or sale of 1. Bridal apparel, including bridesmaids, mother of the bride, and flower girls apparel, and related items. 2. Bridal accessories and related items. 3. Evening wear and related items. And or 4. any category of goods designed, manufactured, marketed, licensed, or sold by JLM. You cannot do anything in the bridal industry until August 1st, 2022 at a minimum. This is in anticipation of her non-compete clause and part of the preliminary injunctive order that will be in effect until that time. You're heavy. Did you know that? A little heavy. I need to start lifting weights so I can just hold Kitty. Okay, you're just going to sit there. Cool. Ms. Gutman next requests the court to reconsider the preliminary injunction provisions granting JLM control of the accounts. Ms. Gutman improperly restates arguments regarding the court's interpretation of her duty to assist with advertising that the court previously considered and rejected. So it's like, no, I already said what I said. Don't bring it up again. Don't bring it up again. So let's see how the court restates that. The court is not happy with the new arguments. Where is the new modification? Conclusion. For the reasons stated herein, Gutman's motion to dissolve the preliminary injunction is denied in its entirety. The motion for reconsideration is denied in its entirety. The preliminary injunction order, however, clarified by the following modifications. So this is until the August 21st, 2021. And then paragraph 3C is hereby modified reading, using or authorizing others to use any designs or any of the trademarks or any variations, versions, representations, or confusingly similar facsimiles thereof in trade or commerce without the express written permission of plaintiff's chief executive officer, Joseph L. Murray. That means no brand deals under the name Hayley Paige or any of the derivatives. So she cannot do anything under her name in commerce because the trademark is her name. And that's during the pendency of this suit under that preliminary injunction. And that is how Laura Taylor Swain feels about it. And that is the court's ruling. And that is what we've got. So the court has again said, no, boo-boo, we're not doing this. The response from Hayley Paige, now I have not seen a response on social media, but I have seen a response from the attorneys. They're appealing it. So we're going to wait and see what happens with the appeal. Let me pull that up real quick, which is, it's hard to do with, look, my mouse isn't working. What have you done to my mouse? Are you just going to sleep here? I think you are. You are hot. You are making me warm. I know. You were twitching in my ear. Let's see what's going on. Why won't this pull up? Why won't this pull up the other part? We need the other one. We need the other one. I know. It just doesn't want to work. My computer's like, you have so many tabs open, we don't care about you anymore. And we hate you for opening this many tabs. Ha, the tab was already opened. Amended notice of appeal filed June 4th, 2021. Defendant Hayley Paige Gutman, pursuant to federal rules and federal rules of appellate procedure, appeals to the United States Court of Appeals for the Second Circuit from the memorandum opinion and order of the Honorable Laura T. Swain granting the preliminary injunction entered on March 4th, docket entry 109, and the memorandum order denying the motions that we just read about June 2nd at docket entry 176. So Hayley Paige and her legal team are appealing, which means this case will probably be stayed pending appeal, and we'll just have to hang out until we are done. Look, we're done. Oh, okay. Okay. Come on. You can stay. I know you're a little heavy, but you can stay. We're just all paw nerded tonight. We're just all paw nerded, but that's it. We're done. We're done. We can get to questions. We're done. I know. Sometimes I bang the gavel, Fred. It happens. Questions with Fred. Legal questions with Fred. I miss Crystal J's. Crystal said, watching you push me to take my LSATs finally. Congratulations, Crystal. Fred, we could be more impressed. Let's be congratulatory. Let's be congratulatory. Let's be congratulatory. Nope. Tired. All right. So those are the things. I'm going to get to questions and then we'll get to court of public opinion. Get out of my kombucha, kitty. This cat. I'm going to swoop back up and try to get to some questions, and then we'll go from there. Question for Fred. Fred, Meow. Nope. I wonder if I did lawyer cat, how he would respond. Hey, Fred, come here. Let's see. Let's see if Fred likes lawyer cat. Hold on. You've got to see the screen though, because if you don't see the screen, it's not funny. Fred, look. What do we think of lawyer cat? Are we confused? Oh, we're confused. We don't like that at all. Oh, we don't like it. Nope. And you guys can't see Fred. You can't see Fred not liking it. Fred does not like lawyer cat. Fred objects to the cat on the screen. He's like, that does not look like a real cat. Oh, perfect question, Linda. I've done the YouTubey things. Have you? There are still over 3,000 of us in this chat. Go ahead and like and thumbs up into the YouTubey things. There is fluff on my face. I don't know how long that has been there. It's going to be that kind of night. Grace says, it sounds like Hayley tried to hold on to something, but it totally backfired, even though there were no real new things. Yep. Hayley very much wants the judge to not do the things the judge is doing. And the judge is like, no, I said what I said. I said what I said. I love that he was sitting there all cute too. But I am hot. And he's going to start knocking things off my desk in a minute. The cuteness is distracting, but we got through the end of the ruling. The weight of the kitty doubles when they're sitting on your bladder. Yes, it does. He does that at 4 a.m., which is a favorite. Pass it. Fred, you're going to knock that glass over, baby. Let's not. If you hear things crash. Carol, Hayley Paige said on social media she did not have a lawyer read her initial contract, but in the court filings, JLM said that there was negotiations and she did. So we don't know based on what's been presented on the record. So I don't know. So this is a great question. Totally Jersey. Would she get her name back in 2022? Nope. No, she sold it forever. They trademarked her name. She sold it. They own the trademark. So she can't do bridal under her name. And during the preliminary injunction, she can't do any commerce under her name until this is resolved. No commerce under her name until this is resolved, and no bridal under her name ever, forever. So nothing under her name forever. Let's see. Carrie said Fred is so sweet. I think so too. Shez says that's not a lot of tabs. It is. It is a lot of tabs. It is Fred because the cats are Fred and George, like the Weasleys. Does Fred get relaxed from Emily's voice like I do? Maybe. Fred definitely comes in when I am chatting. I think he just wanted to come hang out. So I think it's too many tabs. We did a court of public opinion on tabs. Y'all know how I feel about tabs. I don't love having a ton of tabs open. I am like a 5 tab or under kind of a girl. So I do not do it. Brie Patrick, I love how Emily Kames the cat distracts her, yet she's staying on topic mostly, and Chad is losing it over the kitty. I do get distracted more when he's running around. When I can just hold him here, it's easy to focus sometimes, but it's getting very hot in my office. And I'm going to have to turn my fan on for the next live stream. We've gotten to that point of the summer where I'm just going to be hot all summer long. Hot and sticky all summer. Alexis, question, what happens if Tom Girardi dies suddenly? Not to sound cold and callous, but it almost doesn't really matter because he's in a conservatorship. So all the pieces that are moving would just keep moving. If there is a criminal investigation going on, that would stop. So Loki Mama Bear, can you pet Fred? If he'll let you, absolutely. Question, can Hayley form an LLC or some form of incorporation in another name and take brand deals under the new entity? Yep, she totally could. She just can't use the name Hayley Paige or HP or Miss Hayley Paige or anything like that. She could absolutely do it and is doing it because I keep seeing ads from All That Glitters on the gram, which is not under her name, and I keep seeing ads for that. So she can do that. She can do other deals under not her name. She can't do anything bridal related, but if she wants to do protein shakes and pet food and whatever flat tummy tea or whatever influencers are doing these days, she can. She can do that. Question, how is G's shoulder doing? I'm starting PT for a rotator cuff surgery. Oh, rotator cuff is rough. Poor little guy must be miserable. I hope he and Dolphiny feel better. He is just buckled at the top of his shoulder. So it's not, I don't think it's as bad as a rotator cuff. It hurts over the area and he can't go out. So he's just kind of locked down like this. And when he's locked down like this, it doesn't hurt him too much. He's not having any problems sleeping. And with kids, that's generally how I judge how much pain they're in, is to if they're waking up, and he is sleeping like a log. No swimming though. He's super bummed about that. And we had to cancel multiple summer camps, and he's bummed about that, but only like halfway, because he's like, well, it's hot at summer camp in Tennessee, and now I get to stay inside. Jen Hobbs, at least Fred isn't 20 pounds like my male cat. I mean, he's 5 months old. I think he's going to be. He's going to be a big cat. They have really big paws. I think both of these boys are going to be big. I think so. Question, can she trademark a new name and connect them publicly? She can't connect them publicly. Also, can her new name contain any of her original name? No, it cannot, Victoria. I read the provision in one of my original videos on this, and I have a Hayley Paige playlist. They've licensed Hayley Gutman, Hayley Paige Gutman, Hayley Paige, Miss Hayley Paige, all of it. So she could be, Sparkle Glitter Unicorn or Phoenix Rising or Moaning Martle. No, that's Harry Potter probably has that one. She probably can't do that one. She can pick a new name, and she probably will, but she can pick a new name. As a native Tennessean, I apologize for the heat and humidity. Taylor Young, do not worry. We chose it. We chose this life. We chose it. We knew what was happening. We knew what we were picking. Lisa Wigger. Hello, Lisa. It's good to see you. Question, if Clark paid KJ's fees, could he sue her to get the fees back, like for breach of contract? Oh, that bases on a lot of supposition. I don't know if there would be an agreement. If there was an agreement for him to pay her fees, that would probably play very badly against him in the business partner lawsuit. But I guess we'll see what happens. I mean, I don't know. I don't know if he paid her fees or not. And I don't know if we'll ever know that. But if he was paying her fees and continuing to pay her fees, why not just keep rolling the dice on the Westbrooks? Here's the supposition on that. If he was paying her legal fees, why not try to run the Westbrooks down out of cash on both fronts? And the only reason that even came up is because the way that KJ's legal team was spending money in those early filings, with the amount of filings they were doing, felt like you've got money to burn. It was definitely not a conservative approach to early litigation. It was the make it rain approach to early litigation. And you generally don't see that unless there's a lot of money at play. And we made assumptions based on the information at hand about whether we thought that was something we as an online community, and then me supposing these things with Nate the lawyer and Uncivil Law on a live stream ages ago. We supposed, where is the money? Could the business partner be paying it? Would there be a benefit for him? The benefit being you're running the Westbrooks down on two fronts, and they're fighting a two-front war, and now they're not. So that's where that is. Question, do you think Erica could face charges, or is she exempt? By charges, I'm assuming you mean criminal charges. I think if she was going to face anything, I mean, we don't know what she knew. If she's going to face anything, I think there could be accomplice liability there, but that means Tom generally has to be charged. It's very hard as a prosecutor to charge someone with aiding and abetting if you're not also charging the person that they aided and abetted. And so would the U.S. attorneys go after her if something happened to Tom, and Tom's in a conservatorship and you can't go after him? I don't know if it's worth their time, energy, and money. I really don't. Elizabeth Plant, off topic. We're totally fine. It's Q&A time. We're okay with off topic. I don't know if I even swooped into Q&A. I'm sorry if I didn't. Cat distraction. Are you a pool or beach person, or both? I'm both, but I live inland, so pool is the way I'm living now. I like pool. I like lake. I like ocean. I like bodies of water. I enjoy a good stream or river or creek. Natural bodies of water are a lot of fun, but I also like a pool. I played college water polo and discovered towards the end of that I am kind of allergic to chlorine, so I prefer a saltwater pool. So there's that. Absolutely, we can get an RIP for famed lawyer F. Lee Bailey. Oh, Shaylin, your son broke his collarbone at band camp. I mean, that tracks for band camp, and broken collarbones are such a bummer. Such a bummer. SRA 916, this is a great question. Can she create a new brand with nicer bridal stuff? She absolutely can create a new bridal brand under a new name after the end of her non-compete. She can do other commercial activity under a different name until the end of her non-compete, but there is a non-compete clause. So there's a period of time she's going to have to cool her jets for. So, question, can Erica end up with criminal charges if she knew her gifts were purchased with stolen money? It would be really hard to prove. I mean, theoretically, I would have to look at what the federal statute is for receipt of stolen goods, because it becomes like laundered money, essentially putting it into like artwork or putting it into jewelry to kind of launder it if you know that it's stolen goods. But that would be difficult. It would be difficult. It would be difficult. So, yeah, it would be hard to prove. Question, why can't Hayley Paige use HP? Because it's part of what she sold under her employment contract. It's a derivative of Hayley Paige. So she cannot. And can't she claim there are other initials? She could claim that there are other initials, and they are initials for lots of things, but it is also a derivative of Hayley Paige, and that is expressly prohibited in her employment contract. She would have to pick something else for sure. Cute Maker Designs. Oh yeah, he is big for 5 months. He's a very big cat. They have an Instagram account if you want to see how little they were when we got them in March. They are very big now. So let's keep going. I like Hayley Paige. I don't think that'll fly. I think that would be a derivative. Phoenix Rising is a semi-recent YA novel. I didn't know that. I love YA. I'll have to go look it up. I really do enjoy YA. Question, can her new name have a letter from her old name? If I were Hayley Paige, I would steer so clear of anything Hayley Paige because I wouldn't want to continue to be in litigation with JLM. But that's going to be between her and her lawyers to decide. I think it would be difficult. Question, how do you find dry heat compared to humid heat? I've never experienced California-esque temperatures. California in my area didn't get hot like this. And it got really cold at night. So it always kind of cooled down because I was closer to the beach, which made it really hard to like sit out on the patio at night and enjoy it because it would be cold and windy most nights by my home. So the part of California I was in was not like the deserty part. I have been in Arizona in the summer. I don't care what the fuck you say about wet heat, dry heat. 100+ heat is just a no-go for me. I'm fluffy. I like the cold better than I like the heat. I get very red no matter what I do. And heat is always hard. I don't mind humidity. I know it can make it feel hotter, but at least then if you're sweating, you're like, oh, it's the humidity. Somehow it feels better to me. So that, Veronica, I am so sorry. I can't even, and it's been over a year now. I can't even talk about losing Albus, my 17-year-old cat that I love. I'm very sorry and sending you lots of love. It is a very specific and very painful kind of a thing when you lose your lovely paw nerds. So I absolutely get it. Lori, nope. No Hayley Paige, no derivatives of it. So nothing like that. Wendy, you came in when the stream is ending. We still have a little bit of time. We still have to get to court of public opinion. I have a different kind of court of public opinion for you tonight. And yeah. Haley Ann Davidson, question, what was your favorite and least favorite case you covered in 2020? By the way, you're the bomb. Thank you. I appreciate the compliment. Favorite and least favorite. Let me see. Least favorite in 2020. See, some of these things spilled into 2021, and I have to go back and look at everything I covered in 2020. Hold on. I'm gonna pull up my channel real quick and take a peek at my videos so that I can see what I did. Hopefully it won't autoplay. Shush. Okay, good. Don't autoplay. Let's take a look at the videos. And I will take a look at 2020 and see, because in 2020 we covered Kanye, and we started covering Tati. What else did we cover in 2020? So much has happened between like October and now. It's hard. I think the Jeffrey Toobin thing was one of my favorite things to cover because it was just so fucking ridiculous and funny. And it also brought a point to sexual impropriety in the workplace, and it was ridiculous. I enjoyed covering the Tati Westbrook suit. Like it was all of the litigation. We covered all kinds of things in that suit. It was definitely fun to cover. The least favorite suit right now is this newest 90 Day Fiance Sherelle's World John Yates suit, because it's so hard to read. It makes my head hurt and I hate it. The Triller suit, I can't be mad at because it's so bad. It's entertaining. So yeah, if there's something I really hated covering, I just wouldn't cover it, truly. So I can like hate the lawsuit because it's bad, but enjoy the ridiculousness of it. So that's kind of that. Yeah, I think that answered the question, I hope. Question, will we ever find out about the murderous conspiracy? God, Red Bag read books. I hope so. I hope so. I mean, at some point, the judge and the research attorney were reading this going, I don't want this shit show. Murderous conspiracy, ridiculousness. I want to know so badly what the murderous conspiracy is. Maybe Clark Swanson will reach out to another small beauty channel and tell them what the murderous conspiracy was. Maybe we'll find out. You guys go ahead, if you're not subscribed, and subscribed to the things and do it. In central Queensland, humid heat above 100 degrees Celsius most of the year. Absolutely hate it. I hate that humidity unless it's cyclonic weather, as it's rare for rain to occur here. Rain would be hard because rain definitely, the rain is like 100% humidity, kind of cuts the painfulness of it. I love the rain we get here. Y'all are going to see way too much on my Instagram of like cloud formations and shit, because I'm so fascinated by weather and clouds that aren't related to something being on fire. Because that was my experience in Los Angeles. So, Heather Porterfield, I am also dyslexic. I have transposition dyslexia, so I move letters and numbers around. What type do you have, if you don't mind me asking? Oh God, I was diagnosed so long ago. I get line blurs where things melt, and I also get things flipping. So I get letters and numbers flipping. Math was very hard for me because I would get the things wrong in order. So though I don't, and people ask like, what type of ADHD do you have? I'm like, it was so long ago. I need to go and re-diagnose all the things so I know, because things have progressed along since I was diagnosed in my teens. But yes, I flip things all the time and it makes the maths hard. I live for this. Not a question, but my favorite case you've covered so far is Colin the Caterpillar. I love that lawsuit, but it wasn't 2020. That is a 2020 suit. I love the Colin the Caterpillar suit. Love it so much. Douglas, hello. Why couldn't Hayley Paige do Paige Hayley? There is a DJ named Mord Fustang and a few others who have done similar who are well known. Because Hayley Paige's contract says she can't do a derivative of the name, so it would be in violation of her sales agreement of her name. Paige Hayley or Paley Hage would be a derivative of Hayley Paige. So hopefully that helps. Question, how long do you think it will take to hear an answer to RR's filing from the court regarding the Girardis? Probably not long. Probably not long at all. The court will, it probably won't be long, because the court will decide and probably issue a minute order, I would imagine. I don't think it's something that needs to be taken under advisement. It is or it isn't. And with conflict, it kind of is or it isn't. Fets15 random. Where did you play college water polo? UMass Amherst. Played 2. Wonder if we played each other. Eastern Division, UMass Amherst in the 90s, because I'm old as fuck. So there's that. Okay, I'm going to do one more question and we're going to get to court of public opinion. And then I need a Peter Mon style fan for the summer. I really do. I have hats. I need a Peter Mon style fan for in here, because I'm definitely hot. Question, can the trustee seize ownership of EJ's trademarks, copyrights, and videos, which can cost millions of dollars to make, as part of the estate? This is a fantastic question, T. Hamilton. You always ask great questions. It depends on how they were paid for, and it depends on if her company got a $20 million loan and can't pay it back, can that be part of the settlement to pay back the loan? Possibly. So it really just depends on how the money moves and what was broken down. It would be kind of at the end of the thing. But if she gets sued, it could be a thing. Because those are definitely assets that the bankruptcy court might want, though the bankruptcy court is absolutely trying to get money that is liquid and then distribute it out. So we'll see. Dot lived in Nashville for a long time. The rain was nice, but the rain also meant tornadoes and flooding. Yes. Yes, it does. Dr. Riley, thank you. Yes, go Minutemen. MASSACHUSETTS, Massachusetts. Lori Smith. Hey, Lori, it's so good to see you. Hope you are well. Hi, all you wonderful, lovely, and kind peeps. Just wanted to wish you all a relaxing and fun weekend. Thank you. Tomorrow I'll be recording next week's episode of the podcast because I'm behind again. I love you guys so much. You're simply the best. I'm thankful for each and every one of you. Thank you, Lori. We love you too. It's so good to see you in the chat, and I hope you are well. All right. Court of public opinion is a breakdown of, wow, I can't play clips because I will get copyright struck. But not struck, noticed, because, it wouldn't be for commentary. It would really just be for fun. But I'll just give you a hint. Look at this stuff. Isn't it neat? Wouldn't you think my collection's complete? Let's get to court of public opinion. All right. I totally just spilled on myself while I was drinking during the intro, and now I have no lip gloss, but it's fine. We're just going to make it. All right. We were joking about this a bit in the chat. I don't remember which live stream. And we were talking about the contract Ariel signed with Ursula, because it feels kind of like Hayley Paige, the selling your voice. So let's talk about what I didn't know there was a BuzzFeed article breaking down the legal analysis of The Little Mermaid, but we are going to break it down. Now, the chat has had amazing input about Ariel signing away the rights to her voice. Now, when we talk about concepts like unclean hands, and I haven't read this article yet, we're going to do this together. When we talk about concepts of unclean hands being a defense to breach of contract, the Sea Witch got all fucking involved in this shit. Like, she was all up in there flipping over boats during Kiss the Girl and all kinds of shit. She absolutely, well, I mean, that was Flotsam and Jetsam, but still, they were under her control. There were definitely some unclean hands going on with regard to Ursula getting involved in this contract. She didn't let Ariel just try to fulfill the contract on her own. So we're going to go through this contract and see if Ariel's contract with Ursula the Sea Witch stands. Was it binding? Did Ursula breach the contract by getting involved, rendering it void, meaning Ariel should have just gotten her voice back and her legs? Her dad's also like king of the sea. I don't know the age of consent for merfolk, but I don't know. Is 16 age of consent? Was the song at the beginning Ariel's like coming out as an eligible adult? Is 16 kind of her age? And I was talking with Tech Fowler about this before. King Triton did try to break the contract. It backfired. So yes, Anne Elizabeth, when Ursula became the competing woman, I think that it was interference with the contract. I think it's unclean hands. I really do. So let's talk about this legal analysis in this BuzzFeed article, because I am very entertained, and then I want to hear what you guys think of it. Thank you, BuzzFeed and Julia Reinstein, for bringing us this. Quote, the world could actually use more underwater courtroom dramas. Fucking agreed. I love The Little Mermaid. I'm old enough that I saw The Little Mermaid in the theater. I make my kids watch The Little Mermaid. Every time we go to Disneyland, especially California Adventure, we go on the Little Mermaid ride multiple times. Not just because I love it and I like to sing along and I'm that mom that embarrasses my kids, but because that ride has the best fucking air conditioning in the park. So if you need a minute to get out of the heat, the Ariel ride in California Adventure is the best. And then during Food and Wine Fest, if you've perhaps imbibed a little bit much, Abby, if you've imbibed a little too much, the Little Mermaid ride is a perfect place to not jostle your insides because you might be drunk walking around Disneyland or Disney World, California Adventure, but it also gives you the air conditioning. So let's go under the sea, under the sea, under the sea. Okay, before I start laughing about Baby It's Better Down Where It's Wetter and get completely demonetized. Remember in The Little Mermaid when Ariel signs Ursula's contract, trading her voice for legs so she can pursue her one true love, which she's met literally once? We're not going to talk about the love struckness of a 16-year-old because that shit's powerful. 16-year-olds are a force to be reckoned with. Seems like a poor life choice, but anyway, I mean, 16, your brain's not fully formed yet. This is why we don't let children sign contracts. Their brains aren't fully formed yet. Do we think that teens under the sea mature at the same rate? We're going to just have to assume that a 16-year-old is still not a fully functioning frontal cortex. Someone finally gave that contract the legal analysis it was long overdue for and has deemed that Ariel was well within her rights to have it annulled. This is from 2016. I am living for it. I think this is Shone Faye. If I pronounce this wrong, I am sorry. I'm very excited to get into this analysis. London-based comic and writer who wrote the analysis told BuzzFeed News she went to law school and is fully qualified to practice commercial law. Lawyer, comedian, Stan. Ariel was always my favorite Disney princess. Court of public opinion, we're going to have to do who's your favorite Disney princess because I also very strongly relate to Mulan. I also really like Jasmine. Ariel simps a little hard for me, but that's okay. Ariel was always my favorite Disney princess. I always strongly identified with her, probably because we're both trans women, Faye said. I mean, I'm just transgender, where I guess Ariel is trans species. I mean, she's a trendsetter. I never considered it from that perspective. You go, Ariel. But, getting here wasn't an easy ride for either of us. Much appreciated. We stand more. Faye said she recently decided to break down the legal inconsistencies when she was rewatching the movie and noticed Ursula says the contract is legal, binding, and completely unbreakable. And I was like, not sure that's true, babe. I love it. Faye spent about 45 minutes writing out the argument, and dang, it is in depth. Okay, point 1. Ariel at 16 is a minor, while she can enter into a contract with Ursula as a minor, the contract is voidable at any time. After being unsuccessful in winning the heart of Prince Eric, she could have voided the contract and swam away with her voice. We don't know the age of consent. We're assuming human age of consent for the merfolk. Fair. Given that Ariel's voice is given as consideration for her legs. By the way, consideration means the thing that you are given. There has to be valid and due consideration in a contract. This breakdown is brilliant. I wish I had done this in law school. It would have been a lot of fun. As consideration for her legs, Ursula's condition that if she does not kiss Eric in 3 days, she must also give her soul as penalty is arguably onerous and unreasonable. Very true. Like the maritime equivalent of PPI insurance or overdraft charges, Ariel must be able to sever that clause of the contract or have recourse to the appropriate ombudsman. That's very British. Depending on the common law of the sea, which generally defaults to international law, which I only know because of the cruise ship cases I worked on as a research attorney. God, I'm a nerd. Let's keep going. Common law of the sea generally defaults to international law if it's in international waters, but the merfolk may have their own binding laws, which would have been set by Triton, so they probably would have been binding on Ursula, but let's continue. It may be that Ursula has a contractual duty to act in good faith. Unclean hands. By deliberately obstructing Ariel's ability to perform her obligations by means of sending agents to capsize her boat just as she is about to kiss Eric, and by becoming Vanessa and enchanting the prince into marriage under magical duress, Ursula has breached the duty of good faith and fair dealing. Also, unclean hands, unclean hands. When we talk about duty of good faith and fair dealing, this is going to come up from now on. This is the example we're going to. When she became Vanessa the Strumpet and used the voice to make Eric think that she was, in fact, Ariel who had saved him from the sea when she was not. There are more arguments there, I think, to be made, because duress, fraud, unclean hands, and then the marriage could easily be annulled for duress and for fraud. All right. Even if said duty, express or implied, does not arise and Ariel remains in breach of contract, she and Triton would be liable only in damages through query and ascertainable head of loss to Ursula anyway. through query and any ascertainable head of loss to Ursula. Perhaps merely the funds required to make her potion. Interesting. What would be the actual damages? I don't think it's your soul. I think that's a very good point. Ursula has no right to specific performance of her contract because this is an equitable remedy. And the equitable maxim, he who comes to equity shall come with clean hands. I told y'all I didn't read this before. I'm so fucking excited right now. Ursula's hands are dirty and she has been manifestly dishonest. No court in the sea would grant her this remedy. Yes, unclean hands is a defense. Duty of good faith and fair dealing. The sea seems to be an absolute monarchy in which all three constitutional branches reside in the crown. Very accurate point. This American might not have considered the fact that it was an absolute monarchy, so this point is very well taken. Therefore, Triton has absolute power to declare the contract void ab initio on the grounds of public policy or to pass preliminary legislation retrospectively voiding it. Always get independent legal advice. This makes my heart happy. Wait, I need to link this for all of you guys so that we have it and so that we can link it in the chat so that you can read it, because of course Twitter loved this. People were blown away by the contract law masterpiece. Before you agree contractually, darling, it's better to have someone check out the legality. Oh, if Hayley Paige had read this. Quality legal analysis. This is why hiring a good lawyer is important before going into major deals. Same. This is the best thing I've ever read on the internet. Wherever is a hyperbolic statement of enthusiasm and not to be taken literally, this Amal must be an attorney. A lot of people want this case to be taken to the big screen for the underwater courtroom drama it deserves. Agreed, but I think that what is the remedy? Because I think that Ursula voided the contract by her actions for sure. Wait, they say law nerds. Almost. Legal nerds. And of course, the legal nerds of the internet are taking the argument even further. Yes, we are. This is assuming undersea justice works similarly to surface justice. It also ignores the fact that the contract was magically binding. It does. We do need to account for what the rules of the magical people are, because using magical trick to void the contract might be like an extra super breach of the contract. Wait a minute. Isn't Ursula banned from the country or monarchy, making her deals legal by another source? Well, no, it would make her deals illegal. If she's been banned, then she maybe can't enter into binding contract under the laws of the kingdom because she's been banned from the kingdom. Faye said lawyers around the world have actually told her they're really impressed with the analysis. It's a good analysis. Wish the partners at my old firm can see me now, she said. Court dismissed. Kaboom, you've been lawyered. This is fantastic. Also, I love that the ad for Cruella was popping up. Cruella was fucking outstanding, by the way, if you have not seen it. I love this. Do y'all think that Ursula broke the contract with her behavior interfering with performance by her lack of good faith and fair dealing? Or did Ariel sign what she signed and had to give up her soul legally? Who's right? Ursula? Ariel? Who wins? I think that's the question. Law nerds, what say you? What say you? is Ariel in the right to say, Daddy, I didn't mean to breach the contract. Undo it. Undo it. So, Linda says, yes, she broke it. Ursula totes meddled. Agreed. Give her voice and legs back. Unclean hands for sure. I think so. I think Ursula breached it before Ariel breached it because she interfered and interfered with Ariel's performance of the contract. So I don't think Ariel's wrong. Ariel, unclean hands. Ariel, Ursula. I like one for the sea witch. Alexis is like, your rules don't apply here because magic. Or Ariel's a sovereign citizen. Glenn Long. You win the internet. Of course, Ursula's a sovereign citizen. Of course. Now I'm turning red from laughing. Oh my God, of course. Because why not? I love that. Ariel wins. Anne Elizabeth, King Triton fulfilled the terms on behalf of Ariel, who was only freed when she was killed by impalement by the ship because of the magical binding. But I think the magical binding was an unfair provision of the contract. I do believe because of the unclean hands, I don't think she could have legally bound. I think she was wrong on the legally binding. Unclean tentacles. I like it. Ariel was right. Oh, the chat jumped because there are so many answers. Y'all are the best. Ariel was underage. I stand absolute monarchy. I love it. Ariel by virtue of Ursula's unclean hands. Pam, I like it. Ursula was definitely naughty. Truth. Those pesky sea witches. I like Ursula. Like I feel for Ursula, but also, aren't they international agreements then? Take it up with the ICJ. Granted, Ursula can't be compelled to appear, but her global legitimacy could sharply decline. That's absolutely fantastic and a very well taken point. I love it. It should go up with the Court of International Justice. Agreed. I am not well versed in international law, unfortunately. Depends on the version of the fairy tale, but the Disney version Ursula has. Yeah, we're definitely going with the Disney version on this one for sure. Yeah, there are some sketchy legal dealings here. Agreed. If Ursula left her alone, then Ursula could have won. I think so too. I think if Ursula hadn't meddled, she would have kissed Eric and it would have been game over anyway, I think. Because, you should just go around kissing people that I can't judge. I was 16. I won't even talk about me being 16. Ariel, Ursula, Ariel, you guys are coming for it, and I love it. Ursula could have been located outside of the kingdom and therefore could have had different laws. True, because she was banished from the kingdom. So if a citizen of the kingdom enters into a contract with a sovereign citizen, what rules apply? And if Ursula's rules apply, then Ursula can just change the rules. But if Triton's rules apply, then Ursula was wrong. Ariel, but she was ignorant to the law. Ariel didn't seem to read the she didn't read the contract. Could we put together a case for Ursula though? We probably could put together a case for Ursula though. I would need to watch it. Ursula would say, what would Ursula say? Ursula would say benefit of the bargain, that Ariel was not obligated to enter into the contract, that the contract had to be sealed by magical means because it was a magical contract, because that is the only way you give a merperson legs. So obviously there was going to be a steeper price because that is the way things are done under the magical contract law. Lewis says, well, there's a space between the contract's body and her signature, so Ursula could add something in there. She could, and she's magic. So magic. I just think of divine every time I think of Ursula. Therefore, Ursula was up to no good. Glenn Long wins. Agreed. Ursula meddled. Sovereign citizen for the win. I love it. I think there's a legal exception for mythological villains. Maybe we need to look at the Ministry of Magic for this. We need to just cross worlds. There is argument that I'm mixing fan theories here in my brain. That's what happens after 2 hours of live streaming. We get tired. In the book, Ursula wins. I need to read the book. Ariel wins maritime law trumps civil law. And maritime law is its own specific thing. That is fair. What does Natalie Lawyer Chick think? I will need to ask her what she thinks. Ariel Ariel pulled a Hayley Paige. She was like, I don't like it. See, the thing is, I don't think that JLM meddled the way that Ursula did. I would love to know if you guys think JLM meddled the way that Ursula did. Magical contract has magical consequences. And that's a fair thing for it not being undue consequence, because the only way you get to the benefit of the bargain, which is the legs, is through magic. So therefore, the magically binding seems appropriate because it's the only way to actually execute the contract is through magic. Ariel is more of a sovereign citizen than any, depending upon which time we're talking about, because she is on land or water. She's a princess as a mermaid, but is she still one with legs? That shall be. That is a very good point. But she signed the contract under the sea, under the sea, under the sea. She signed the contract under the sea, presumably within the bounds of her father's kingdom. So I think that she would have been bound by the laws, but Ursula might not. Was it notarized? Kiki for life, a very good question, but we saw her sign it. And we know it's her. So does it need to be notarized because there were witnesses, because it was animated, because cartoons. So was the fish pen magical? Because why didn't Ariel just write to Eric and tell him what's up? You make an excellent point. I don't think she thought of it. Hey, Eric, it's me. You don't know me. I saved you. You were passed out. You might have seen me, hair blowing in the wind and all. I lost my voice to get legs. I'm coming up. We're going to find out if it's better. No, she's 16. It's not funny. It's a cartoon, folks. Maybe this is why in real life, Bob Iger dumped 50% of his Disney stock shares, over $100 million worth. Maybe. The insanity of this is a beautiful thing. I mean, fair. It's very fair. Would the ocean she resided in have state or provincial specific laws? The boundary of the laws of the country that border the sea only extend for, let's see, how far offshore? Before you're in international waters. How far offshore does international waters start? Let's see. In 1982, in a 1982 United Nations treaty, which was ratified by most members of the UN, it permits nations to claim territorial waters up to 12 nautical miles from shore and a contiguous zone up to 24 nautical miles from shore. The United States has now also adopted those limits. So it depends how far out in the sea it would have applied. So it depends. I think she's kind of out in the water. I'm going that she is out beyond 24 nautical miles and that she is well within Triton's kingdom. But is Ursula a sovereign citizen? Hubby walked by. What the hell are you listening to? A legal breakdown of The Little Mermaid that we're going to have to go over again on Tuesday. So this is the best conversation I've ever seen. Thank you, Angel K. This is giving me life. I love it. Should look into the Kingdom of Sealand. We absolutely need to. Just an FYI, Ariel is not a minor based on Disney's age of majority. Snow White was 14 when she got married. Jasmine was 15 and Belle was 17. What's with them trying to hypersexualize minors? I have issues. Why are they all so young in fairy tales? Why are they all so young? We need Octonation to weigh in on this. Nicole, you reminded me of this. We need Octonation to weigh in on the law of the sea for sure. Question, did they have maritime law in the 13th century when The Little Mermaid took place? I mean, probably not. It was probably like pirates' law, just law of the land. But these make an excellent point. Poor unfortunate souls. All right, y'all. Yeah, I'm not going to be able to stop. I'm not going to be able to stop either. Floyd Mayweather just showed up at a Bitcoin conference in an Ethereum shirt, and they booed him when he said there will be another crypto bigger than Bitcoin. Doesn't he have a fight to focus on? What is he doing? What is he doing? What is he doing? Maybe the Atlantic Ocean has different laws to the Atlantic. I don't know. Maybe. Ursula was banished from the kingdom, so I guess her and her grotto are their own entity. I mean, making her actually legitimately a sovereign citizen. Would Sebastian have technically been acting as her legal counsel? I mean, he did give her advice against signing the contract, didn't he? Oh, was Sebastian practicing law without a license? Was Sebastian giving legal advice? Oh, he might have been. This is a very good question. We've got to look into Sebastian. Was it sketchy? I don't know. Was he giving legal advice? As counselor to the king, it might have been construed as legal advice. Either way, she ignored it. So I don't know if it helps. All right, y'all. Thank you for a fun chat. I will put this up on social media. I will formulate the question and link the article and put it up on social media tomorrow for you all to vote on the Twitter and on the community tab. And I will love to see your arguments there. This has been a fabulous Friday Night Live. I appreciate all of you. I will see you on social media this weekend. I will see you in a new one on Tuesday, provided I am feeling okay for my second COVID vaccine. If not, I will let you know. If you're in the text crew, you will probably know first. What else? That's all, really. That is a fun Friday night. It is 9:24. A huge thank you to the moderators for hanging in there this evening. And our final super chat for the night from Living Sweetly. Once Ariel became an underage human being, the contract is a non-necessity contract, or its terms are detrimental to the minor in the eyes of the court. It is voided as per international law. I love that take on international law. Once she becomes human, it becomes automatically void. I mean, I love it. I think there's a strong argument there that the contract changed in nature when she changed in species. I think. Sebastian ESQ under the sea law school. Thank you all. Thank you, mods. And I will be back on Tuesday. We'll see what we rule on this contract, and we'll continue to chat about it. See if I formulate any other legal arguments. I'm going to have to rewatch The Little Mermaid again, and it's going to be a lot of fun. So, all of you, thank you. Be safe. Have a great weekend. Enjoy the beginning of summer. Happy Pride. Happy June. Have a great night. Thanks for hanging with me, everybody. I'll see you in the next one. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube